Number 154, People versus Matthew P. Okay, counsel. You want any rebuttal time, counsel?
Yes, Your Honor. I would like 2 minutes for rebuttal, please.
Okay, go ahead.
Thank you. May it please the Court, my name's Amy Donner, and I represent appellant Matthew P. A defendant can't...
Tell us how the two causes of action here are the same or different as our earlier precedents in terms of these kinds of situations. The theft of services as opposed to the first cause. Go ahead.
Okay. We're speaking about point 1 of my brief,
Yes,
I gather.
go
Okay.
ahead.
Thank
Go
you.
for it.
That's what I wanted to talk about. Thank you. Okay. Well, basically, my case...
You know, because we've been here before.
Yes.
In this general vicinity.
Right. Well, in Napo, certainly.
Go
And
ahead.
basically, the cases do sort of fall into 2 categories. And basically, one of them is where there is an actual pre-existing business relationship with a customer. That's Spattarello. And in that situation, where the complainant in Spattarello, complainant Garbage Company A, had this pre-existing business relationship with the customer. Garbage had been hauling. There was a stream of money. It's interrupted by the defendant's extortion. So the defendant stole the customer, this existing business relationship, in this transaction. There's larceny. Then you have the cases like Napo, which is just like my case, and Hightower is based on Napo, and my case, where you have this potential business relationship, but the complainant does not have actual possession of that transaction.
You're confusing me, but that's not
I'm sorry.
hard. It's okay. What did your defendant do wrong? I mean, it seems to me when he takes, money and lets people in, and that there's a violation of the penal law somewhere.
Oh, yes, definitely.
What do
He
you call
committed
it?
a violation of the general theft of services, which statute, which doesn't use the term owner. It doesn't use the larceny law concepts. It specifies MTA.
But the problem is, in petty larceny, property is could be defined as including this exact activity. I mean, it says in the statute, so you're taking a substance or anything of value in the last section, including gas, steam, water, electricity, which is provided for a charge or compensation. So
But-
the subway fares, you're taking I don't get why that isn't a taking.
Okay, but there are 3 things that property can't be, and it can be broad, as Your Honor said. But there are 3 things that Napo and Hightower say it can't be, which is money that the complainant does not yet possess. Here, the undercovers
But
and
they're not taking, he's not taking, what he's taking is access to services.
but there's this potential business relationship. Appellant, had the undercovers and appellant not had this great deal of, $2, get in all 3 people instead of $2.50 a head at that time. It's now $2.75. But, they might have decided to walk or take a bike. They didn't, they had free will.
They
They didn't.
undercover police officers?
Well, police officers you would think would get in for free. But the bottom line is it's $2.50 a head. Certainly appellant, it was $2.50. And instead, the choice, they had free will. They didn't have to do it that way. There's only a potential relationship.
If they had charged him with stealing the key, would this be not a case now? Because didn't he have a key?
He did, but there was no charge there wasn't a charge about larceny of the key, and we don't know how he got the key, and definitely there's illegality here.
Well, considering the nature of the crime, when is it not a potential business relationship? When they're about to swipe the card? And I said, don't swipe that card. I got something better for you. When is it not potential anymore?
When they go through the gate, and the MTA has the money.
I understand, but then there's no reason to offer someone to go through. Right?
Well,
The position has to be that there's no way to ever read Spattarello to apply to someone like this who does this.
when there's
It can't be that it's after they go through, because now they've gone through. They're not going to give him any money.
He's
But
not going to give the money to
but-
the MTA.
Hightower, that was the exact situation in Hightower also.
Well, except Hightower, there'd already been money that had been paid for someone to go through.
But the very next sentence, what's interesting, and that certainly made Hightower an easier case, But Hightower, the very next sentence distinguishes Spattarella in Hightower. And it says, by contrast, in Spattarella, the victim was compelled to give up a business customer whom
Those are all really great, and they're academic, and I'm not that far ahead. It just seems to me that if your client is standing there and people are coming through for $2 and they should be paying $2.75 now, or whatever it is, and he does it all afternoon, your argument is, well, that money was never given to the MTA, so it's not a larceny. So, you can't charge him with petty larceny. You can only charge him with theft of services?
which is the same level crime.
No, is that a yes?
Yes, because of the definition of owner, which is a larceny concept, and own is possessed.
So your complaint on count one is, I stole services, I didn't steal money, therefore you should throw out the steal money count.
That is part of my argument, and that's certainly what...
Larceny this is not just, it doesn't, stealing services is not the same as stealing money. What about Cablevision? What if I steal cable? What am I stealing there? Am I stealing the cable fee, or am I stealing access to the cable services? You could be charged with both petty larceny there or theft of services.
It all goes... Oh, I'm sorry, I don't want to interrupt, Your Honor.
You make your point.
It all goes down to the definition of owner, and owner is possess. And in Hightower relies on NAPO, if you haven't possessed something, like in the taxes had not yet been paid.
Okay, so in the $2,
NAPO.
The petty larceny was not, the complainant should not have been the MTA, it should have been the person he took the $2 from? He's got $2 that he shouldn't have, right?
Uh-huh.
All right. So he took them from somebody.
But that's...
All right, so who can go to the police and say, he took my $2? You're saying the MTA can't, right? Because it's not
Well,
their
I'm
money.
saying that the MTA isn't an owner because it's likely unremitted taxes.
So you're
yes.
saying the MTA can't because it's
Exactly.
not their $2,
Right.
even though for those $2 he got on the train. The guy that got on the train, can he say he stole my $2?
I don't think he would.
Can he?
I don't know. I mean, he certainly could say that petty larceny wasn't satisfied because the MTA was not the owner.
So your client didn't commit a crime?
He did commit a crime. He committed theft of services, which was specifically meant for subway services as property. That's what the legislative history says, but it also doesn't use the larceny concept of ownership.
Counsel, could I just ask you,
Yes.
You said something in your brief about if we don't remit or we don't reverse the petty larceny, that we shouldn't send this back? Or if we do, I guess if we do reverse the petty larceny, we shouldn't, and I'm not suggesting that we will, but we shouldn't send this back because it would serve no purpose?
Yes,
Did you say
I
that?
requested
So-
Burwell relief. Yes, as in Hightower.
Yeah, could you just explain that?
Well, in several of this Court's cases, you've held that where the defendant has already served their sentence and it's a minor crime, this Court has granted Burwell relief rather than have yet another case in the system. You know, Burwell, Flynn, Hightower, Dryden. There have been a lot of cases like that.
And you said if we don't reverse, then you would want to affirm on the other, on the theft of services?
Well, I had two independent, I mean, there are two information, so point two is an independent claim. In either one, we requested Fugazato relief.
Okay.
And Burwell relief,
Thanks,
too.
Counsel.
I don't know if I'm...
You'll have your...
Sure. Okay.
Good afternoon, and may it please the Court. My name is Ryan G., and I'm here on behalf of the people.
Counsel, what's your petty larceny claim?
My petty larceny claim, Your Honor, these were not just potential customers, and this was not just a theft of
How
services.
does it differ from our other cases in this area?
Sure. What sets this apart from Hightower
On the larceny, yeah.
on the larceny is here because defendant used a stolen transit authority key to open an exit gate that he had no right to open and allow people into the subway system whom he had no right to allow in, all without the MTA receiving a penny whatsoever in return.
You're focusing, counsel, on the mechanism Right, but that's not what I understood our Hightower case to focus on. It was focused on the definition of owner.
Well, I'm sorry.
Because I believe the court said the Metro card, which was a valid form of getting into the subway. And you're saying now that the difference here is that he had a key that he wasn't authorized to have, but I didn't think that was the focus of Hightower.
Well, why the mechanism matters, Your Honor, is because it gets to whether the MTA actually lost anything. Because as this court, and if I could just quote this one sentence from Hightower, we decline to extend the reasoning of Spattarella to these facts because here we must assume that the transit authority voluntarily transferred this valid Metro card in a manner consistent with its ordinary course of business by selling the card and receiving the price it set.
When does a potential customer become a customer?
In this case, when they went into the subway system, they went past the gate which separates non-paying, perhaps potential customers who might just be, wondering if they should get onto the subway station, and people who have actually accessed the subway services once they.
Before or after they paid the money?
I'm not sure this record. It seems rather contemporaneously.
But if they go through the gate, they're not potential. I mean, they're on. They've done.
Exactly.
I think they've gotten through and paid the money, and they're going to get on the train.
Exactly. That's exactly right, Your Honor.
So they're not potential. So, right, the potential is right before one does that. Or am I misunderstanding your argument?
No. I believe that we're on the same page, Your Honor, and that's where I differ with opposing counsel.
When he goes to them and says, "I can let you through," are they potential customers at that moment?
Yes, at that moment, right. If they have not yet entered the subway
They're
system.
potential customers before he goes up to them, but they're close to the gate.
Correct. They're close
Are
to
they
the gate.
potential customers when they're on the last step to walk onto the area where you have the toll booth? In other words, at what point are you a potential customer? Which is the same question I asked before, the same question that Judge Stein is asking you.
I think they would be a potential customer up to the point that they've entered through the gate
But
into the
that's not
system.
even, how far back are you going?
Well, I mean, I guess anyone in theory could be a potential customer, but if I could just clarify.
Certainly by the time they're up near the toll booth. That seems like you're pretty serious about getting on the train.
Right. But we're not arguing here that defendant stole a potential customer, of course. We're arguing that, and what the appellate term found is that defendant stole business that was presently and exclusively within control of the MTA, and that's how we get to owner.
That's why I asked when they paid the money, because if they paid the money before they went through the gate, is there an issue there?
No, because they went into the gate. And so they were customers of the MTA who were accessing the MTA services because defendant used a stolen key to allow them in, and the MTA received nothing in return. And if I could just.
What if the defendant had given them a stolen Metro card and they didn't go through the gate at that point? They, maybe took it and stuck it in their pocket. Then what do we have?
Well,
If anything.
in your hypothetical would be. It's a stolen Metro card, but it has value on it.
Yes.
I mean, obviously that's a different case, but I guess what I would say here is that I think there's still a theory for why that could be larceny, because even if they don't go even if they don't go into the subway system at that point in time, they have this card which would allow them to when they want. And part of the MTA's business
Why are
is.
they not at that point just a potential customer? They haven't decided they're going to take the train or not take the train.
Because part of the MTA's business is also selling the Metro cards themselves. Because, of course, once you have the Metro card, which you buy outside of the gate, then you can go into the subway system or use the bus or, use whatever other public transportation system that one can use with a Metro card. So I think it would be at least arguable that would still constitute larceny. But again, why this case is even more stark is because, of course, they entered the system. And what, again, sets this case apart from Hightower is that essentially in Hightower, the MTA did receive the business of the other person who went in. Because as this court made sure to note throughout its decision in Hightower, that case was solely about a valid, paid-for, transferable, unlimited Metro
We're
card.
getting into the Internal Revenue Code, I swear, with the technicalities on these. But as Ms. Donner says, I mean, why isn't it just theft of services? You got a whole statute that says that.
Well, because, it would not just be theft of services, Your Honor, because again, theft of services is really would be about the other people going into the subway. They're usually, as I'm sure this Court is aware, they're usually turnstile jumpers, or like in the second case, someone who goes through an exit gate without paying. And so could defendant have been charged here as an accomplice to theft of services? Possibly. This Court, I would just note, left that question open specifically in Hightower, and again, it's not before this Court in this case.
So you don't think he was guilty of theft of services?
Well, I think, again, I'm not sure if he could have been charged with that. This Court left that open with Hightower, but
I'm asking you, you're the people of the state of New York, and you say, this guy did something. What did he do? And you're saying he did not steal services. That much we're sure about. What we think he did is steal money that belonged to us. Is that the thinking that went into this?
Well, no, what I'm saying is even if he was an accomplice to stealing services, he did something more. He did something additional, because it wasn't just facilitating.
Couldn't theft of services also be a petty larceny?
Yes, it could be. And so
This happens all the time in the criminal law where, they're close to each other. There's
exactly.
similar transactions.
Exactly. And as this Court found in Maddox, in another transit fraud-related case, overlapping offenses does not mean that only one
Judge
offense.
Pickett's got a good point. You probably should have charged him with both, huh?
Well, no, I mean, I think we charged him with the crimes that were most appropriate to his offense. And I would just to quickly correct the record.
We don't see too few charges. Usually we see too many.
Well,
I don't know why you didn't charge him with the key.
he was charged with the key.
Was he?
He was charged with criminal possession of stolen property, which was based on the key, possession of burglar's tools, which is based on the key, and there's never been any dispute.
You did overcharge. That makes me feel better.
Well, no, we charged him with all of the most appropriate offenses. And so, of course, there's been never any challenge whatsoever to the sufficiency of the stolen key specific.
But he pled guilty to the theft of services charge and the petty larceny to get the concurrent sentence, right?
Correct.
And the others were dismissed?
Right, they were, right. And then there was also a third case, unrelated.
What's the scoop with that? I'm thinking, we could send it back and he could find himself facing felony murder. I don't know, what's the third one?
Well, I'm not sure if I can discuss, those records are under seal, so I'm not sure if I can discuss them now. But yes, I mean, obviously, I believe our argument should carry.
So I'm clear, you're saying that this case is more like Spottarella as opposed to Hightower because this was the use of a key as opposed to a valid Metro card?
Well,
and it has nothing to do with whether the MTA or the New York City Transit owned the $2 that he received from these undercover cars.
I'm actually saying both, if I could just explain. The reason why it matters that he used a stolen key is because by using that mechanism to allow other people into the subway system, he prevented the MTA from receiving anything. So people got into the subway system for free. And the business of those people, the revenue from those people entering the subway system was owned by the MTA because they went into the system. And what's different from Hightower, of course, is that the business of the person who went into the subway system by means of a valid Metro card had in fact been received by the MTA. What the defendant in Hightower did wrong, if I can put it this way, is he just built his own business on top of the MTA's business. And whatever other offense that might be, that did not deprive the MTA of any property because the MTA had already said, here, you have this valid, unlimited Metro card. You can swipe any one you wish into the subway system within the, time restrictions. See my rate? If I could just.
I think we understand your argument. Let's hear from your adversary.
Thank you.
We think we understand our argument too, but we'll find out.
That's all we can ask for. Thank you.
Counselor.
There's a lot of language in Hightower. I mean, there is the one line, and that makes Hightower a much easier case for your honors. Because happily the MTA did get money out of that.
When you say if we find in your favor we should not send it back, is it? I stand corrected. I now looked at the record. He was charged with resisting arrest, false personation, I mean, shouldn't we send it back and vacate the plea and let him go forward on all those other ones?
Well, this was the one count he pled to.
No, but
and
it's the one non-jurisdictional one. At least you're saying there's no jurisdiction for this one, and it would seem to me that if that's the case, there were a bunch of others that there was jurisdiction for, that he should have an opportunity to defend, don't you think?
This was the way that, the relief that was requested. And he wasn't charged, by the way, with petty larceny of the key. I just wanted to clarify that.
Criminal possession of stolen property in the 5th degree for the key, I think.
Right, possession of stolen property, but not the larceny.
My point
what I
is that
meant.
it seems to me that, I mean, if it was a really smart lawyer that said, you know, they don't have any jurisdiction on this one, so we can plead out all of these and then raise on appeal the fact that there was no jurisdiction on this, and it just seemed to me that maybe that's not fair.
Well, I mean, Your Honors can do whatever it is that you want to do. That you want to do on that. But he actually, the way the plea was, it was for swiping a Metro card, which didn't even make any sense. So,
Okay.
but I just did want to quote. There's a lot of language in Hightower that doesn't have to do with that circumstance about the Metro card. It says the amount of money. Well, first of all, we had the very next sentences distinguishing Spattarella about already being in the control and possession. But also the amount of money paid to Hightower could have been due and owing to MTA, but as was the case in Napa, which is my situation, that you don't possess something that you haven't got, that you've never received, like the taxes, that were due, the state didn't own them.
So essentially, you're saying there's no real difference here between the Metro card and the key?
Yes, it has to do with whether or not, because there was only this possibility of a relationship.
You said the same thing about the business relationship in Spattarella, that yes, they had their past business, but they didn't have their future business.
But nothing would have been, there was a contract in Spattarella, and even if there wasn't,
They could have breached the contract.
but it was an ongoing situation which was only interrupted. Here you still always had, the possibility of walking or bike ride if you didn't get this incredible deal. And all the language in, Hightower is about how it's like Napa, and that Napa only owed taxes, but the state didn't own the unpaid taxes. And just that Deceptive Services specifies that MTA is a complainant. It gets you around the owner, Subway Service, and it's because the legislative history had said that Subway Services are not property. Thank you. And there was no felony murder.
Thank you. We got that too. Okay, thank you.